May I have your lordship's leave to mention item number 70 of today's list? Your lordship
70.
70, my lord. Your lordship will remember, my lord. This was appearing yesterday, my lord. It was laid by the learned Solicitor General, my lord.
Oh, yes, yes.
My lord,
10th, 11, which date?
9th, my lord, 9 2 p.m. If first item could be possible, my lord. 9 2 p.m. My lord, the other side is also
70, you are for the other side.
Lord has recorded adjournment on our ground, my lord. My lord.
It is on your ground.
Yesterday we appeared, my lord. So
You can appear?
Yes.
my lord, but today anyway, my lord. Thank you, my lord.
My lord is calling item number 2. Or I'm sorry, my lord.
If you allow. Just wait. Yes.
My lord is calling item number 2.
If you allow.
My lord, I was trying to enter. My lord,
Just wait. We have not called 2 yet. I don't
my
think.
lord, my lord.
I know one. I am for them. This is my application for restoration mill.
Restoration.
Yes, Lord. 7th it was dismissed. 9th I filed.
So 2 dates you did not appear.
Yes, my lord.
2 dates you did not appear.
No. First date. The second date I missed the item because of my lord.
Before you say no, you should go through the record.
Yes, sir. First date,
Consecutive 2 dates you have not appeared.
before that date I appeared. On next date, my lord, I followed it. Intercourt appeals are taken up on Wednesday and Friday. That I have missed, my lord. That's why. Before that,
For whatever reason, it was on the list, you did not appear.
I missed it. This is my brought down to us.
So that's a different thing. Don't say no. We are not making up something. We are saying what is in the record. An application is filed for restoration.
If Lordship hears the matter, Lordship, pardon me for the day because I am having a back strain or I find some problem, Lord.
You have a copy?
I've asked you. I am
Good, please. Yes.
I'm getting it. But make it next monthly list, but I am some problem. I'm carrying.
All right.
Because-
First week of September. Give a date, first week of September.
Number 2.
My lord, I appear for the appellant.
Yes.
My lord, I have a cause today, my lord. My advocate on record, my lord, met with an accident. My lord, he could not come for 7 days. Some severe accident. He was hospitalized also. If permits, my lord, Lordship may kindly keep it on the next week, my lord.
Lordship, kindly keep it on 25th August, if possible.
25th?
Yes,
you want
Lordship.
a date fixed? Why?
Lordship, actually, Mr. Torunjyoti Theory will appear in this matter on behalf of Torunjyoti Theory will appear on behalf of Union of India. So, if possible,
My lord, in other way around, my lord, I could be ready, but for myself, my lord, I am today, my lord, I am at Chandigarh before Punjab Haryana High Court. But
Oh,
I could come tomorrow, but physically, but my AOR melod is not there. Melod. He would be 25 melod. I think there would be no problem. Melod. He also has told me melod.
as jointly paid list on.
My melod has kept on 25th. Grateful, deeply opposed.
Lordship, in
I
item
appear
number,
on behalf of the appellant writ petitioner.
Lordship,
I'm for the Lordship. I am for the NBSTC.
Your Lordships had given me leave to file an affidavit in opposition. Lordship, we have committed a great mistake. Lordship, your Lordship's order had two parts. If your Lordship kindly comes to the order dated 1st July, Lordship, the second, page 3 of your Lordship's order, we were directed to call, Lordships are directed to call upon the AGP to file an opposition so as to substantiate whether such classification is founded on any intelligible differential. Lordship, that specific part is absent in the affidavit that we have affirmed. Lordship, I seek to file a supplementary. I'm very sorry for it. Lordship, because I've served on my other side. Otherwise, I would have filed afresh.
The affidavit in
Plea under order 8 rule 3, 4 and 5. There is no denial to that.
No, that is why there is a
I am equipped with the decision of the Supreme Court that there is no specific denial to the plaintiff case.
yes.
Grateful Lordship.
yes. Getting for some time. This is the only issue. You can substantiate it. It is not a sustainable classification.
Which one are you raising?
Assigned matter.
Yes, since Honorable Acting Chief Justice had personal difficulty with it.
Yes.
The two questions that was for considered that has fallen from consideration. First of all, at the drop of a hat, whether the tribunal was justified in summoning the AGM the BSNL in a contempt proceeding when the order has been complied with and the gentleman has retired from the service 2 years ago, although the fact remains this fact was never brought to the notice of this tribunal. What happened with the 2022-1, the gentleman concerned was transferred from Calcutta to Karnataka. He was released.
Calcutta to
Karnataka.
Karnataka.
Now, he relied on a policy, that was framed by the employer, way back in 2009 September, saying, that the spouse placement, should be taken into an account. Now, this was
For
not
transfer.
for transfer. Now, this policy, according to him, was not adhered to. The gentleman joined the service, in the year 2010. Thereafter, a transfer was affected. He said that I did not raise any voice. The moment, the transfer affected, from Calcutta to Karnataka, he insisted the authority to consider the policy, and in the teeth of the policy, according to him, that this transfer was not legal. Be that as it may, he was released immediately thereafter. After the release order was made, he moved the Honorable Tribunal. The Honorable Tribunal had passed certain order, the authority to consider it. The authority considered and compliance report was filed. Thereafter, this compliance, did not, cause any happiness to the applicant, and accordingly, a contempt application CP 61 of 2024 was filed. In such contempt application, the tribunal was of the opinion that, there is a prima facie, element of contempt, and the order of the tribunal was not, and the tribunal directed the AGM to appear personally. Being agreed by and dissatisfied, that this gentleman was not, in the office, the authority who was the petitioner for your lordship, BSNL, had moved a writ application, before your lordship's court, WPCT 94 of 2026. This writ petition was disposed of by an order dated 28th April 2026 by this honorable court, directing, the granting liberty to the writ petitioner for your lordship to make an application stating all the points, we filed, which was registered at MA 420 of with the tribunal, in connection with the contempt CP 461, in connection with the original way number 350 of 2024. The tribunal thought fit and proper, by its order, that whatever may be the compliance, by our order dated 29 September 2023, this was in aberration of the Supreme Court's order as well as the order, passed by the tribunal. Accordingly, the tribunal rejected, my MA application without considering the facts narrated therein. Our simple contention before the tribunal was this: good, bad, indifferent. When the consideration was made in terms of the tribunal's order, if the gentleman is agreed, he has to file, a writ petition, original application before the tribunal in compliance of, the judgment of the Supreme Court, J.S. Parihar's case, 1996 6 SCC, page 296, subject to correction. And second, Justice, the Honorable Supreme Court, presided over by Dr. D.Y. Chandrachud's judgment, which was circulated to your Lordship's court also, subject to correction, which says not at the drop of a hat, that you must summon the officers, when there is a compliance report. The compliance may be correct, may not be correct. But question is, that I went to the extent that, mere violation is not, does not attract, the contempt jurisdiction, because it has to be a willful and deliberate. The court, possibly thought fit and proper not to lend its ears, to our, contention, and, decided to proceed with the contempt application. On this score, I have come before your lordships.
There is the copy of your MA. Copy of your MA.
Yeah. Copy of MA, just a minute, 232. Paper book 232 minutes, paper book number 2. Paper book number 2. কোথায় গেল গো? 3 এই ববিদা কোথায়? রাজবেনটা কোথায়? চন্দ্রচূড়, ওকে বলো, ও তো দায়িত্ব। চন্দ্রচূড় সাহেবের জাজমেন্টটা কোথায়? জুনিয়রটা করবো? ও আচ্ছা। অর্ডারটা কোথায় বেরোবে? ইম্পিন অর্ডারটা এই প্রতিষ্ঠান আমরা ধরবি যা একটু পাসওয়ার্ড চাইতে বলবো, বল না সুমনকে ফোন করে 500 টাকা। ओ दूर जा अपने मन को बोल
Can you show us the two orders of 12/6/23 and the subsequent one 18/4/24?
33 is 12/6 433 page. That is paper book number 3, volume number 3. Good, good.
And the later one 18/4/24?
18?
18/4/24.
Oh, 18/4. 142. And the speaking order will at 146. 18th April 2024.
$146.
Speaking order dated 18/4/2024. Detailed order, Miller.
So after this order of 18/4, the impugned order is before us.
Impugned order is before the dated 2nd July 2026. Volume 3, last page.
No, this 18/4/24 order is the genesis
Genesis, in a way.
of this
Yeah,
order,
yes.
of the impugned order.
Yes, Genesis. That is my understanding, subject to what but I have not armed with the affidavit of service. I served Miller, that is my advocate on records assertion. The track report is with me, but affidavit of service is not ready. I must tell your lordship, because I should have said at the outset, I thought
When is the date in the matter next?
28th.
28th of August.
28th, 2020. Darana.
Serve a copy, come back tomorrow.
No, I served. That is the report, the delivery report. I undertake to file the affidavit of service in course of day.
File it, we'll take it up tomorrow. File it, we'll take it up tomorrow with the affidavit of service. In the meantime, please inform whoever represents, usually BSNL. If
He
they,
has refused, I have made a specific avowal.
very well. Just tell her or him, whoever it is, that tomorrow we'll take it up for consideration. Let affidavit of Five.
Fly back to your evidence.
Well, this is that matter I had mentioned, you know, one day after it was mentioned and fixed on the ground of my seniors, my counsel not being available. I prayed for it to be taken up on the 20th, instead of today, if it's subject to everybody's convenience. 20th of this day
Day
after.
after tomorrow.
Very well. On a prayer made. Item 6.
Mr. Honorable Secretary, on behalf of the appellant, my lord, today the fix the matter, my lord, before the circuit based, my lord. Kindly note this, my lord.
Yeah, my lord, there's restoration application hearing today.
You have filed the reply.
Yes, sir.
Then file it today. File it.
So, my lord,
You will file it during course of the
yeah,
day.
my lord.
Huh?
Previous, it's not with lying with me, my lord.
What is that? I can't understand what you say. You don't have it.
Give me password, I will file.
You file it during course of the day.
Yes, I will.
Learned advocate for the.
Item 7. This matter, Mr. Dipendra is having on spot. On spot. Yes, come.
Where is he?
Or it's on the way.
On the way. At 11 o'clock.
My lord, volume 2, my lord, page number 133.
One 33.
Yes. The writ petition is directed against an order dated October 20th, 2009, by which the Director General of Border Security Force had rejected the petition filed by the writ petitioner against his trial by summary security force. The petitioner is a dismissed constable of the BSF who was charged seated on April 11, 2009 by the commandant of the concerned battalion of BSF. The petitioner was charged with the offense that at almost number 4A of border output of Kakmarichar, he was performing his duties on the night of December 15, 16, 2008 when he improperly omitted to take due care and cause caution, as a result of which 10 to 12 smugglers along with 12 buffaloes and 6 calves crossed over towards Bangladesh. One of the smugglers was apprehended. 8 buffaloes and 6 calves was seized by the special Ambas party of the concerned border outpost. Upon a plea of not guilty taken, the petitioner was tried by the summary security force. The prosecution produced 3 witnesses who were cross-examined, and the statement of the petitioner in defense of his case were also recorded after he had signified that he did not intend to produce any witness in his defense. The SSFC, by an order dated April 13, 2009, sentenced the petitioner to be dismissed from service. The petitioner thereafter filed a petition under Section 117(2) of the SF Act, and the said had been rejected. Mr. Bhattacharya, learned advocate of the petitioner, has assailed the filing on various grounds and submitted that in the fact of the case, an order of dismissal was not warranted. He has taken me through the evidence that was adduced by the witness and submitted that the cumulative effect of the evidence, if taken in the true perspective, must be held be inadequate for holding the petitioner guilty for the charge. Mr. Sinha, learned advocate for the respondent, submit that the decision impugned in the writ petition suffers error, no infirmity, and has been passed by the respondent upon compliance of all the procedural formalities and appreciations of the evidence on record. The company commander submitted a report relating to the incident to the concerned commandant, and based on that, the petitioner was called before the summary security force court. According to him, the petitioner was given due opportunity to cross-examine the witness but declined. Mr. Sinha further submitted that after compliance of all the requirements and after going through the record of the evidence, the commandant found a prima facie case has been established against the petitioner, and the order of dismissal from service was rightly passed.
Where is the order?
Yes, ma'am.
SSFC's order? The SSFC order.
FC order.
Yes, my lord. Page number 92 of volume number
1. Para 92 page.
Where's the type copy? This is the
Volume 1,
that is the last page of the order.
My lord, here in this verdict, the commandant didn't pass any opinion, my lord, as per rule.
Madam, we are asking a question.
Yes,
Please
my lord, last
respond.
page of this
It
order.
is the last page of an order.
Yes,
Where
my
is the
lord.
earlier
Sentence
pages?
of the court.
Where is the earlier pages of this order?
My lord, there is no order as such. Only this order he passed very arbitrarily.
Cannot be. There are pages before this order.
Yes.
No, my lord, I didn't find any.
See, at the top it says taking all these matters into consideration. So there must be something before this.
Yes.
I now sentence the accused. This is only the sentence. Where is the order? You filed an opposition before the learned single judge?
Yes, ma'am.
Yes, it is 130.
Position, madam, page number. Page 113 in volume 2. 113. Page 130, my lord. Volume 2, my lord. Affidavit of opposition on behalf of the respondent. Paragraph D, last question. SSC accordingly, he was tried by holding summary security force court on 13th April 2009, and after due appraisal of the evidence produced before court SSFC, the petitioner was found guilty and was sentenced by the court to be dismissed from service. Habitual offender.
I think so, because here they have said. Hmm.
But if you allow me, I can brief up the matter in small so that you can know that what are the gross anomalies in the prosecution.
There is a again,
Many times we have seen it. Yes, 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 yes. You still don't have your list of books here. এখানে দেখো ওর তলাটা দেখো আছে না the second one. BSc, BSc. Proceed course. Sleep. Huh? Which page the single judge order is at which page?
single judge order.
From 133 it is starting, my
Yes,
lord.
my lord, 133.
133.
Yes.
Volume 2,
In volume
volume 2, 132.
2.
Happened to the book. So many cases we are seeing that book every day. Must give something. Yeah. Not very good ground for setting aside. Then proceeds to go into the sufficiency of evidence. Yeah. Not done. Hmm. Yes.
Yes, my lord. If you allow me, my lord, I can show you the gross anomalies in the prosecution, my lord. My lord, the allegation is that it was a dark.
Madam, not arguing an appeal. What is the procedural infirmity? Which procedure was not followed? Tell us.
Yes, I'm.
The learned single judge has gone into it as if it is sitting in appeal over the departmental proceeding, going into sufficiency of evidence. How it can be done in a writ proceeding?
My lord, in Rule 148,
Yes.
it says that before passing a verdict, court should give an opinion based on evidences. But
Correct.
where is the opinion in this order?
So where
Page
the,
number 92.
where the honorable single judge has held that for not giving an opinion, we are interfering or I am interfering with the order. Show this finding.
Yes, my lord. There are other procedure.
There is no.
There, yes.
First, show us.
On 137 page.
Yes, please read.
A similar question cropped up for consider from 136. I'm starting, my lord. A similar question cropped up for consideration before Delhi High Court in the case of Nirmal Lakra versus Union of India. In that case, also the petitioner was tried by the SSFC court, and the respondents had taken a point that in terms of Rule 149, reasons are not required to be assigned. It was submitted that there was a pro forma under the BSF rules that no reason was therefore required to be given at the same time. Negating the contention of the respondents, the division bench had held that a person's right to liberty as guaranteed under Article 21 of the Constitution of India cannot be allowed to be toppered in a casual manner. It was held that the principles of natural justice had three pillars. Assigning reasons is one of them. The importance of assigning of reasons must be gauged from the situation as mentioned in the judgment. After considering a large number of judgments, decided that in terms of Rule 148 of the BSF rules, an opinion is required to be given, and such an opinion can be given only when reasons therefore are assigned. In SSFC court, an accused is deprived of the benefit of the service of the law officer in terms of Rule 83 of the BSF rules read with Rule 149. But while dealing with a situation where the liberty is a person is involved, Rule 148 must be construed liberally. Forming an opinion is a mental act, and the same where it is reduced in writing could not be expressed in one word as guilty or not guilty. The division bench thus held that it was highly desirable that a court constituted that the BSF Act would assign reasons, the correctness of which can be judged by the confirming authority as well as the court exercising the power of judicial review. This court is keenly aware of the limitations of a writ court while exercising jurisdiction. The writ court, as is widely known, is not sitting the court of appeal over the finding of an inquiry.
So therefore, then it goes into the sufficiency where it has said that for non-recording of an opinion, it is bad.
Well, nothing is given over here. Only it is given taking all these matters into consideration and now sentence the accused, the K.C. Mondal, to be dismissed from service, my lord. And if you go through the incident, if you kindly allow me, you will understand what gross animals are there in the
We are not
prosecution.
going to reappreciate
my
the
lord.
material and evidence. We are not going to reappreciate.
Yes, my lord.
That's not the scope of review.
And also, my lord,
You are allowed
actual-
full participation in the proceeding.
Yeah.
There is an allegation of some lack of diligence on the border, madam.
my lord,
It has led an incursion
my lord,
of whatever it
my
is.
lord, it was a foggy night, and the prosecution rested on surmises and conjectures of the two SIs. Two SIs only the prosecution rested, and also on hoof marks. And the thief who was caught, he was released. He was never brought in the prosecution. Another person, another constable was there in the same ambush. He was not brought in the prosecution, my lord. Just for the vindictive attitude they have concocted these stories to spoil his career. And if you see in page number 105, my lord, you will see the character. There is no previous record. Only except on 19A, when he went to his home for his wife's delivery.
So what is the scope of 148? That is a limited issue. We are not going to travel into the sufficiency of evidence.
My lord, on that the register was also not signed. They came out and there was no seizure also.
You may try hard, but we will not go that way.
My lord, I am
We will not
on
look into the evidence.
you are questioning,
Yes.
I'm giving you
We
answer.
are asking you 148 whether requires a finding to be recorded based on a reasoning or not. That's the only thing.
Yes, my lord.
What is the meaning of the expression opinion used in 148?
Opinion.
Now,
Opinion.
is there any judgment? Then show us.
Yes, Nirmal Lakhara's judgment is there, my lord, where the same honorable
Where
single
is it?
judge.
Show us.
It is given in the judgment itself of the single bench order, my lord.
You don't have copy of the judgment to show to the court.
My lord, I
Just
don't
by
have,
reading the name, we should understand that it is all correct.
I'm not carrying that
Why you are not carrying?
given over there. I
You insist that you want to read today and you are not here with this
have
judgment.
two separate judgments, my lord.
Show us which judgment we are asking you.
Those two judgments are different, my lord, where natural justice is violated.
Madam, again and again we are asking you. 148 compliance.
Yes, my lord.
You insisted that the matter be heard today and you are not ready.
I'm ready, my lord.
Where is the judgment? You are saying it is mentioned in the single judge order. If everything was
Yes.
correct, then he would not be here.
My lord, one judgment copy, only one copy is there, my lord.
You cannot. You are appearing before a division bench.
Yes, my lord.
Learned advocate for the respondent. for an adjournment.
I'll come up with,
Just you insist that it must be taken up and then you are not ready. Wastage of time.
come up with the judgment. Deeply obliged, madam.
Item number 8.
I am appealing for the appellant writ petition, I mean.
Time for the respondent.
It is been admitted position that I was terminated from service without initiating any disciplinary proceedings. The honorable single bench observed that the procedure by which I was terminated is illegal. But the learned single judgment did not interfere with the appeal. He kept the appeal intact, and that's why I favored the appeal. Man, you also kindly have a look to the first to the order, my lord, of the honorable single judge. Page 3, my lord, of the order. This court, however, finds that the said judgment is indeed applicable in the facts and circumstances of the instant case on a matter of principle. A delay of 6 years in verifying antecedents and a subsequent termination without a lawful inquiry is indeed is violation of 311. Now we will also kindly have a look at the appointment letter. The question is not whether the petitioner was a permanent employee or not. Yes. This part, this one. Lordship, kindly have a look to the appointment letter, page 22, page P3, and annex P3 of the writ petition, my lord. This is to inform you that on satisfactory completion of training, you are hereby appointed provisionally to the post of route driver conductor in the scale of such and such plus other admission. And the conditions, your service will be guided by the CSTC Employees Service Regulations. Your lordship kindly have a kindly note that your service will be guided by the CSTC Employees Service Regulations. Now you will be on probation initially for a period of 1 year, as envisaged under Regulation 17 of the which may be extended to 1 year. So period of probation is 2 years, maximum period is 2 years. On completion of 2 years, when I am deemed to be a confirmed employee. Yes. Regulation 17A says, my lord, on completion of satisfactory 2 years service, an employee is deemed to be a confirmed. Now your lordship kindly come to the CSTC Employee Service Regulations. (17A) has been inserted by amendment, my lord, page 9, bottom. 17A, an employee who has successfully completed the period of probation referred to in Regulation 17 shall be deemed to be a permanent employee. Now your lordship kindly have a look to the Regulation 39. Regulation 39 says, my lord, no order of dismissal, removal, or reduction shall be passed on an employee of the corporation other than order based on facts which had led to his conviction in a criminal court, unless he has been informed in writing of the grounds on which it is proposed to take action and has been afforded an adequate opportunity of defending himself. So order of termination cannot be passed unless the delinquent is given adequate opportunity of hearing. Now, what is adequate opportunity of hearing? That has been explained. The grounds on which it is proposed to take action shall be reduced to in the form of definite charge or charges, which shall be communicated to
You have also challenged the order.
No, I have not. This was a query put to me on the last day.
The grounds on which it is proposed to take action shall be the form of a definite charges or charges which shall be communicated to the person of charging of definite charges which together with a statement of the allegation on which each charge is based upon together. Now, he has not been given any opportunity of hearing.
But the single judge directed.
But the order of termination remained intact. He did not interfere with the order of termination. Order of termination must be set aside.
So shows that you are deemed confirmed service.
Yes. Regulation 17A, your lordship has says. Now,
where is we have not seen. We were going through the order and you were show us where is the
Regulation 17A.
Yes.
Regulations are handed over to you. Hand up. Regulation 79. Page 9, Your Lordship, kindly come. Page 9. 17A was inserted after amendment, my lord. In the bottom portion, my lord. I will refer the judgment of the Supreme Court also.
17A.
Your Lordship, can bottom.
Is 9.
An employee who has successfully completed the period of probation referred to in the regulations shall be deemed to be a permanent employee.
So where is your successful completion of probation? Where is the
I
success?
was term.
Where they have said that you have
No, but after completion of 2 years, I
No,
deem
no,
to
successful and
Yes.
period are two different things.
No, no, no.
Successful means that you have to be
Because
successful.
had I was an unsuccessful candidate, then they could
So
have.
there is deemed
It is
successful. There is
dream thing. I'll refer to
Please show the
Supreme Court judgment
Yes.
also. On completion of maximum period of probation, if
Sir, it is not a period, it is successful. Successful.
yes, they have
Now,
not
show the law. Yes.
yes, they have not terminated my service during the
Let us
2 years.
see, let us see. Show
I
the
was successful. I was allowed to work
Let us
after
see.
2
Yes.
years.
Let us see.
I will refer to judgment. Around. I already handed up the judgment of the Supreme Court on 2010 to Supreme Court cases, page 169.
10-2.
2010 to Supreme Court cases, page 169. Now I'll refer to judgment where Supreme Court says on completion of the maximum period of probation, if an employee is deemed to be confirmed.
10-2. Yes.
Now I'll refer another judgment of Supreme Court to 2015-17 Supreme Court cases, page 549, which says, right to hearing and right to appeal. That is, unless an employee is confirmed employee, he
In
cannot.
this judgment, you are relying on which paragraph?
Supreme Court 2010, my lord.
Which
Yes.
paragraph you are relying on?
Your Lordship, kindly come.
Where is the paragraph which says that immediately after the period is over, there is deemed confirmation?
Paragraph 7. No, that I will refer to. This is, my lord, with regard to antecedents of the petition.
That comes later.
Yeah, 2000 Supreme Court, page 2070. Paragraph 12. Paragraph 12, Your Lordship, can have. Fifth paragraph, yes, quoted decision of the Supreme Court, whether an employee at the end of the probationary period automatically gets confirmation in the post, or whether an order of confirmation or any specific act on the part of the employers confirming the employee is necessary, will depend upon the provisions in the relevant service rules. In these cases where the rules provide for a maximum period of probation beyond which probation cannot be extended, this court has held that at the end of the maximum probationary period, there will be a deemed confirmation. So, the maximum period of probation. After 2 years, the employee should be deemed to be confirmed employee. Now, the rule provides, my lord, Regulation 17A provides, my lord, that maximum period of probation is 2 years, and on completion of 2 years successful probationary period, he will be deemed to be a confirmed employee. Now, question is, they could have easily been terminated by my service during that 2 years. They did not do that. Apart from that, Regulation 39 has been violated by them. It says no order of dismissal can be passed. I will be covered of the CSTC employee service.
To go to the next point, while we are still reading, can we understand anything?
Yes.
You have shown a judgment, let us read the judgment, then go to the next point. One point after the other.
Yes, yes.
For what purpose?
Start করেছি। গাড়ি স্টার্ট করেছি।
Yes.
Now you'll also kindly come to the appointment letter again. Clause 1, my lord, your service will be guided by the CSTC employee service regulations. Term number 1, your service will be guided by the Calcutta State Transport Corporation employee service regulations. Now, what regulation 39 says? You'll also kindly have. No order of dismissal, removal, or reduction shall be passed on an employee of the corporation. I am to be guided by this regulation. Other than an order passed in conviction, unless he has been informed in writing on the grounds on which it is proposed to take action.
This 17A is inserted to which provision? Where is the parent
17,
provision?
that is
Where
extended.
is the parent provision?
17. After 17.
After 17, 17A
It is page 4.
Page 4. Also, you will see 16 also.
Yes.
Yes.
Lordship will kindly see, the main issue raised is that whether he was deemed to be confirmed, treated to be a confirmed employee, getting the benefit of regulation 38, 39 and all. That is the question raised in the writ petition. Now, my lord, regulation 16 is regarding, my lord, verification of antecedents. If it is not verified, not found satisfactory, shall be terminated. 17 starts with the opening words, unless otherwise provided in any individual contract, all employees shall be. Now, these opening words, my lord, a contract to the contrary, that is not the appointment letter. If your lordship not comes back to the appointment letter once at page 22 of the writ petition, 22 of the writ petition, my lord, I'm reading clause 4. The appointment will be subjected to your antecedents and character being found satisfactory. You will be deemed to be confirmed in service on satisfactory completion of the probationary period and subject to police verification report. Now, what was the report? Lordship now kindly takes our affidavit in opposition.
Page.
Opposition is separately handed over to your lordship because it is no paper book has been filed. We have given a copy. A copy has Lordship will take this copy.
Just give us.
There is no second copy. The petition is here. There will be one copy.
There is no second copy. This is the first copy. Oh, this is opposition. Which page?
Opposition, my lord.
Give us second copy. Give us page.
Page 9. This is the report of the Special Superintendent of Police. Kindly refer to the memo number cited above. It may be stated once again that during inquiry, the educational qualification and date of birth of the VR candidate, Sri Jivan Bahadur Thapa, could not be substantiated, as no records in the name of the candidate was found available at the concerned school. Moreover, the national status of the subject remained questionable in course of inquiry. Hence, the matter was referred to the Assistant Secretary of the Government of West Bengal, Home Police Department, to decide over the suitability or otherwise of the subject. His present employment, government considered the subject unsuitable. As such, this office has nothing to do in this respect. Further communication in this regard, if required, may be made directly to the concerned government authority. This was a report which came.
And this led to passing of the order by you.
This led to the order.
Where is that order?
That is, my lord, part of the writ petition.
Page 24 P5. Page 24 P5 of the writ petition.
We have invoked, my lord, Rule 16 of the Employee Service Regulation, Regulation 16, read with clause 4 of the appointment letter.
Which page was the appointment letter?
Page 22 of the writ petition, my lord. Clause 4 makes the probation subject to police verification, specifically. So that is the not contract to the contrary.
This says both satisfactory completion subject to
I submit, my lord.
And he is not one of the completion of completed and subject to verification is verification. See page 22, clause 4. Application is there. Question why there is only one copy of the brief?
Because they have not filed any application in support of the appeal. So the writ file was called upon by your lordships.
How we can proceed like
And we have
this?
supplied
Where is the second copy of the writ petition?
writ petition.
Where is second copy of the writ petition?
Detailed copy is second copy.
Only one copy. So we'll have to rely on this. Ask him to give another copy
of the writ petition.
Yes, not possible. Why you are not filed
My learned friend submitted that.
Forget about submission. The record is incomplete. What submission? You are arguing a case. You know what is the procedure. You are following every day.
There was no direction for filing affidavit.
Then why an opposition was filed?
On prosecution.
Opposition was
in the
filed.
writ petition, my lord.
Writ petition filed.
Normally,
Why
the ruling is that
in an intra-court appeal, why opposition is to be filed?
Lord, may I clarify? No rule is to file paper book. Rule is to
Yes.
file paper book.
Yes.
In this case, normally we file application.
File paper books will postpone it. Therefore, we keep doing it.
Huge time. You lost to file.
Every
Now,
day we are
in
seeing
the meantime, the petition has
everything.
returned.
Every day we are seeing
Meantime, the petition has returned.
whatever it is. Just see, despite that you have not made it ready for us to hear.
Paper book, I will serve a copy of the. I will file a copy.
You should have done it.
Yes, I will copy. Writ petition.
Every day we are taking up matters.
Yes.
Application is being filed for stay, and in that all the documents are placed on record.
I should have filed.
You should have done that.
Yes.
After going through so much, how we can proceed unless his lordship has
I'll file a copy of the writ petition.
Mr. Swensolan. Number 9. Should not proceed like this. Statute recognizing a contract itself saying that it will be statute itself says subject to any individual. So the statute acknowledges and recognizes that individual contract act because it's not clear.
Lordship, this is the affidavit of service.
That must be the reason. Otherwise, why is it?
Lordship, we have served the entire set, the memorandum of appeal, application for condonation of delay, and the stay application. Lordship, we have
Served.
Yes, Lordship. There is a delay of 216 days.
Let's see. How many days of delay?
216 days, Lordship. We have, I'm afraid, a very, but Lordship, from paragraph 6 of the my application, from page 4, Lordship, we have explained the delay in filing this application, and as to Lordship, it has
The report.
gone through a long process of files moving, the briefs being misplaced.
Yes, what is the order?
Lordship, the order, Lordship, is regard the writ petitioner, Lordship, had joined in the graduate scale of pay as an assistant teacher. Now, when he had joined, he was already a holder of an honors degree, Lordship. But
The holder of
had a degree, an honors degree.
honors degree.
Yes, in English. But he had joined his service as a pass in the pass category. So it was, Lordship, I mean, in 1990.
Why the qualification was?
Yes, the requirement was pass graduate. And
Was there a cap on the higher qualification?
Lordship, at that point of time, that was the requirement. He came as a pass graduate.
No, we appreciate that that is a basic eligibility. Was there a capping on a higher eligibility that a higher qualified candidates cannot participate?
Lordship, at that I'll have to check the advertisement whether there was any cap or not. That is that I don't
Because you said he was having the higher qualification at that time.
at that time.
So based on his higher qualification, he was getting the correct pay scale.
No, Lordship. Actually, he had joined as a past graduate. So he was getting the scale of the past graduate. He was not getting the benefit of the honors. Now, in the slightly impugned order, the learned judge had relied on clause 12(3) of the ROPA rules, Lordship.
What does it say?
Lordship will kindly come to the judgment that has been quoted. Lordship, clause 12(3). Lordship, all teachers, including physical education teachers and librarians of secondary schools who have will improve their qualification, who were appointed with higher qualification in the subjects or group relevant to their teaching appointment, shall get higher scale of pay appropriate to their qualifications with effect from 1st January 1996 or the date of improving qualification, whichever is later. Lordship, relying on this provision of the ROPA.
So he was appointed with higher qualification.
Lordship, thereafter, Lordship, this rule has been amended in 1999. That is not appearing in the order.
What is the date of his joining?
2001. Lordship, his date of joining is? Yes. 2001, he joins.
So on that date, this provision was not applicable.
It was not applicable.
Where have you stated
Lordship,
this?
that is our stay application, Lordship. I have, in fact, Lordship, I'll hand over your Lordship's circulars, which are much more
Have you placed on record
the
document by which this
yes.
was repealed or superseded?
The stay petition contains those
Where
records.
is it?
But Lordship, I'm just handing over, but Lordship, these documents are in the stay petition apart from the act, but they are more legible, Lordship. It's very difficult to read from the stay petition from what, and it's from, Lordship will kindly come to, I shall, Lordship, state petition, Lordship comes to page 47. Lordship comes to page 47. 47 is the last part, Lordship, that is the amendment to the clause that is dated 13th of July
1999. Yes.
Lordship sees para 3, all teachers, including physical education teachers and librarians of secondary schools who have improved will improve their qualification, or who are appointed with higher qualifications in the subject or group relevant to their teaching appointment will get higher scale of pay appropriate to their qualification with effect from 1st January 1996. Or the date of improving qualification, whichever is later, provided that such higher qualified teachers in the relevant subject group.
So this is
Lordship, I'll just
reproducing the
read on.
same thing.
No, Lordship will kindly, I'll read on. It starts from there, but the change, Lordship, sees it's thereafter, Lordship. If such teacher is appointed through the West Bengal School Service Commission, her pay will be fixed in the scale of pay as her qualification mentioned by the West Bengal School Service Commission. So this is where, Lordship,
This will not, this can,
Lordship,
if he was or she was not appointed by the commission, then she will not get, or he will not get.
Lordship, I shall come to the later changes, Lordship.
Later change was perhaps, I remember seeing in one case that it became in the relevant subject. Higher qualification in the relevant subject.
Lordship, he had the higher qualification prior to appointment. Thereafter, Lordship,
so how that can be a disqualification for a higher scale, which is given to all who are having a higher qualification?
Lordship, I shall place the other circulars which have been, including the 2005 Act.
Come with all these circulars, yes. Matter number 10, please, your lordship. My lord, may I most humbly invite your lordship to an order passed by a coordinate bench on 28th August 2025. My lord, with the consent of the parties, hearing commenced. The admitted positions between the parties are that the appellant writ petitioner, pursuant to his selection, joined on deputation on January 7, 2019. The appellant was initially repatriated on September 19, 2019, without giving him 3 months' notice. The appellant assailed it by filing a writ petition, and this court, in view of the said flaw, stayed the effect and operation of the repatriation order. However, during the pendency of the said writ petition, the respondents, by an order dated September 20, 2019, had withdrawn the repatriation order. Accordingly, the aforesaid writ petition was withdrawn. On October 1, 2019, after the said writ petition was withdrawn, in view of the withdrawal of the repatriation order, a fresh order of repatriation was issued against the appellant. This was unsuccessfully challenged by the appellant hearing in the second round of writ petition, being WP number such and such. The impugned repatriation order was issued with the finding that the appellant was found to be unsuitable. However, this order regarding non-suitability was also withdrawn on December 9, 2019. The learned single judge, after hearing both the parties, by order dated March 18, 2021, dismissed the writ petition. Learned counsel for the appellant submits that the appellant was selected on deputation, and hence it is not a normal deputation. Reliance is placed on such and such, reported at such and such. However, he fairly submits that those 3 years for which the appellant was sent on deputation are over. The appellant's rights were protected by the order of this court passed on November 15, 2021. The clock admittedly cannot be put back by putting the appellant on deputation for those 3 years for which he was initially selected on deputation. However, since an arbitrary order is passed, this court can bring the appellant on deputation for remainder of the period. During the course of hearing, it is noticed that in opposition to the stay application, page 123, pana 7, the respondents have averred, with regard to the contentions made in paragraphs 13 to 20 of the writ petition, I deny and dispute all the allegations which is contrary thereto and or inconsistent therewith, save and except what are matters of record. The said order dated January 17, 2020 has lost its force owing to the post being rendered redundant due to efflux of time. The said post was required till January 6, 2022, and as such, there is no such post as on date. I deny that the learned counsel for the appellant, by criticizing the averments of this paragraph, submits that a post cannot become redundant in a department. One can understand that the post is filled up or the post. So, was an affidavit filed after
Yes.
this? Where is that?
That affidavit, your lordship will be pleased to find. There's an affidavit on record which was affirmed sometime on 19 September 2025. It is in the back sheet of Ankit Chatterjee. I'll finish.
19/9/25.
My lord, 19 September 25, yes. Now, my lord, it has been affirmed by an assistant director vigilance of the National Youth Board. Has my lord very kindly got it? Paragraph 1. Then he refers to the order. My lord, Justice Roy has got it. Paragraph. Now, kindly see paragraph 2. I state that while an order dated 28/8/25 passed by the division bench comprising such and such, the Honorable Court had intimated the respondent to appraise this court with the following information, which are answered as hereunder.
whether the post in question, namely Director Technology and Technical, which was occupied by the appellant, is still lying vacant, and since the appellant was admittedly occupying the said post on deputation basis, the respondent shall indicate by filing an affidavit about existence and the status of that post. Answer 1. So I state for the sake of convenience the following two aforesaid questions are answered together. I state that the said post has been lying vacant since 1st January 2020, the date of repatriation of the writ petitioner to his parent cadre after serving 3 months notice period. I further state that in terms of the guidelines of the expressed office memorandum dated 4th January 24, issued by the Department of Expenditure, Ministry of Finance, Government of India, a post lying vacant for more than 5 years from the date of creation or date of falling vacant shall stand abolished. Emphasis is placed on the very fact that such abolition was an automatic process which stood abolished on account of efflux of time. Hence, the question of vacancy of the said post occupied by the appellant does not arise in the instant factual scenario. In case the post be filled up or it is abolished, the decision indicating the same shall also be filed along with the affidavit. It is in terms of clause 5.1 of the office memorandum dated 4th January 24 issued by the Department of Expenditure, Government of India. As indicated above, the said post ipso facto stands abolished by efflux of time originating from the vacancy of such post for more than 5 years, as iterated in the said office memorandum. A copy of the office memorandum is annexed. I state that the deputation of the present appellant was dealt with in accordance with the office memorandum dated 17 June 2010, issued by the Ministry of Personnel, Public Grievance, Pensions, Department of Personnel and Training. The said office memorandum categorically enumerates transfer on deputation, foreign service of central government employees to ex-cadre post, state government, public sector undertaking, autonomous bodies. I further state that para 9 of the office memorandum deals with premature reversion of deputations to parent cadre, which stipulates, however, as and when a situation arises for premature reversion to the parent cadre of the deputationist, his services could be so returned after giving an advance notice of at least 3 months to the lending ministry and the employee concerned. I state that in terms of the above referred office memorandum, as also indicated in the preceding paragraphs, there are no requirement of my lord, exception.
Yes, what do you want to say?
Lord, please page 5 of that exception.
What is your stand?
The stand is the same gentleman who has affirmed the affidavit on behalf of the NGB. He was, but it is incorrect actually that the post stood abolished by efflux of time or there was no post. On the contrary, the same gentleman, by an order dated 13 May 2025, was directed to officiate as a Deputy Director, Technical and Technology, in which post I was, selected. So, the factual that what I want to say is,
no, therefore you are saying that there is no question of abolition because somebody is on the post.
Yes, the same gentleman.
Not only somebody, somebody is that person who is affirming the affidavit, saying that the post is abolished, though he is occupying the post.
This is the fact. But this being
whatever it may be, how you can be put back, that is the only thing.
The issue is today.
Let us for the moment assume that the post is very much in existence. There was an appointment on deputation. That deputation was found to be unsustainable for some reason. We are not on that at the moment. They said you are not suitable. They have reverted you. They did not comply with a 3-month notice as required for reversion. Whatever it may be, the 3-year period for which you were deputed is over.
With respect, not
19 to 21.
Selected on deputation.
Outside we said appointed on deputation.
Yes, appointed.
We understand what you are trying to say. It's not deputation. We have understood. Therefore, we are saying whatever it is, the fact remains. Whether it was a deputation simply star appointment by promotion, whatever, As a deputationist, you were entitled to continue for 3 years.
At best.
At best. That also subject to a right that they may repatriate you at any time.
Yes.
Following that 3 months notice. That 3 years is over. Then what is to be done?
Today,
What does the law say? Let's
say today, if I am, I'm able to persuade your lordship, then this reversion, whatever did take place then, that reversion, if it is declared to be a bad reversion, then
that's what we are saying.
Then that is the
tenure having lapsed. What is the consequence?
The remainder period for which I was illegally not permitted to continue. That period has to be made over or something has to be done. Your lordship would have to mold the relief accordingly.
That would be provided as a deputationist. You had an indefeasible right to continue for 3 years.
My respectful submission to your
lordship. You have to make all submissions acknowledging a fact that you are a deputationist.
My respectful submission to your lordship is,
it's not a simplistic posting to a tenure post. It's a deputation to a tenure post by way of an appointment.
Writing applications.
Maybe that we have understood what you're trying to say. But the fact remains that you are not.
Today, someone who is working in the Air Force, I have got back my, the parent, I've returned to my parent cadre.
You have gone back?
Yes.
And got promotion.
But it is not the question. My learned senior friend, I cannot argue with him. I have the highest regards for him.
I to argue with
I have the highest regards for him. I cannot say anything. But one thing, kindly visualize. A person cannot be answered to shoulder there.
The 3 month notice, if it is not given, you are entitled to pay for 3 months.
3 months notice has been given.
Given.
Second, for first round it was not given.
For second time it was given.
Yes.
Then what remains?
What remains is, if today someone.
The first one you withdrew.
Withdrew because they withdrew the order.
So that is over. That cannot be reopened.
Today, what I am.
Can it be reopened?
What I am essentially on is, subject.
No,
but it's an academic issue.
It's an
academic issue. My submission to your lordship is, I am correct, but my submission to your lordship is, the law as it stands, the provision of solicitor can do. If the provision is solicitor, can do. Reversion can definitely take place. But the moment they use the word unsuitable or unsuitability, that unsuitability has some parameters. Someone has to want to work.
In the second order, they have used the word non-suitability.
Kindly seize the order.
Second order.
During the pendency of the first writ petition.
No. Second order.
I'm sorry.
After withdrawal of the first writ petition.
Yes.
What is the date on which the first writ petition was withdrawn?
I'll just give you a much.
1st October 2019.
1st October 2019.
So after this date, show us an order which says you are repatriated because you are unsuitable.
On the same day, page 40 of the appeal papers.
You have a book. This is a paper book.
Yes.
Page 40.
Yes. But it's the same date. Same date. 38 is my withdrawal.
Sir, perhaps taking this into consideration, you withdrew the writ petition.
With respect, please pardon me. Kindly see page 36 first. 36 capital A. My first reversion order was 19th September 2019, which was withdrawn by 30th September 2019 at page 36. Then I withdraw the writ petition at page 38.
So not suitable for the post. This is the 3-month notice.
Then page 40.
Yes, 40 is the 3-month notice.
Are not suitable for the post.
So
that is not suitable, it's a stigma.
it is.
It is a stigma.
Then how you got your promotion?
Promotion is in my parent department.
So therefore, what stigma, sir?
That stigma.
There is a concept of walking off one shot. Once you have got a promotion, nothing can be taken into consideration anyway.
That is, your lordship is looking at 70 Supreme Court, but there are subsequent developments in law, which says even a good remark has to be communicated. Even an excellent remark has to be.
It's not an ACR entry.
But it is not.
It is not an ACR entry.
Which is on my career for the rest of my life.
That it according to what we are perceiving at the moment, it is more in your mind.
No, with respect, no.
Because you have not disputed the submission advanced by the learned advocate for the respondent that you have got a promotion thereafter. So what stigma?
Well, I have to take instructions on that. I do not know. He may be more poised with my facts. I am not aware about this.
If you have got a promotion, where is the question of stigma?
With respect, I have to take instructions on that. But please, permit me to show your lordship then page 41. 40 I have shown your lordship. 41 is my representation.
What order you are expecting from the court today? Tell us.
The order is, today, in the light of the Honorable Chief Justice's, Honorable Coordinate Bench's order, made in August 2025, the Honorable Court wanted certain things to be clarified. They have incorrectly placed facts before your lordship just to.
They are asking you what order you expect today.
If today, these incorrect.
That already you have submitted, that there was an order, this information was required, it has been furnished, wrongly furnished, whatever it is. What order you expect today?
If this entire exercise, culminating in these various orders, is declared to be arbitrary, then what happens is, these orders go, and ultimately, if it is held that this repatriation or reversion was banned or arbitrary, then some
was not a reversion, it was a repatriation.
Repatriation, it was arbitrary if it is held to be so.
Yes.
Then in that event,
it will result in a reversion. You will go back to the lower posts.
With respect, may I answer your lordship? I'll get back the balance period for which I was selected.
On the lower posts.
In the post that I was selected here. Is in the Air Force or not here.
See, it is all being earned by the same individual.
Yes.
So you can't say it is in this organization and that organization. That will not separate the things. If there was a stigma in your in the department where you were repatriated, could you have done the promotion? Because stigma could not be without your department being involved in the process. It cannot be done.
That is what precisely has been done here.
That you are submitting, we have understood. That you are
that is what precisely.
That is your submission, we have understood.
One day they will.
So you have still not told us whether you have got a promotion.
I have to take instructions.
Give us, tell us that.
Promotion to a higher rank on the same scale of pay. That is my instruction.
So therefore, you have been promoted. That means.
Promoted.
There is no denial of a promotion then.
Promotion kindly ignores this promotion aspect for a moment.
How can we? Your own issues have stigma. Where is the question of stigma after this order? You have the right was saying, you please leave it aside.
Kindly. I permit me to the entirety of the order made by the coordinate bench, apropos the rules.
How many times we will read it, sir?
That portion I'm not ready.
We have read it. We have understood what the coordinate bench was asking.
Today, if your lordship is,
the ultimate question remains right of a deputationist. Will these deputationists wanted or selected as a deputation?
There's a distinction. 2012 judgment carves out an exception.
Yes.
Carves out an exception. It is not a simple deputation.
Sir, whatever it is all your rights are coextensive with the tenure and all deputations subject to a repatriation in accordance.
My lord, see the rule first, page 72.
Come to page 40, then tell us what is shown ceremonious about this order.
My lord,
110/2019.
My lord, kindly see.
Because there is nothing else other than 110/2019.
Kindly see. My lord, please see page 40, your lordship.
Read it. Read it.
My lord, page 40. National Jute Board has borrowed your services from Air Force on deputation. Wide such and such, AIR, All India, I mean, this is Air Force data. Your services are not suitable for the post of Director Technology and Technical. You shall be relieved and repatriated. You know, this not suitable casts a stigma. You know, it casts a
So
stigma.
two submissions you are making in the same breath. That it casts a stigma, and after this I have been promoted. Though in the same scale.
It is not here. Kindly pardons me, my lord. Promotion is, my lord, in my department where I have been sent back.
Now,
From where I was borrowed, let us say.
very well.
My lord, please see.
So whether this stigma will have its effect now.
My lord, the stigma would,
How it will affect you today?
my lord, this recording by itself is a stigma for the rest of my
How
life.
it affects you today? Please tell us if you have got a promotion in the department. Where else will you get it?
For whatever.
We are not in academic.
72.
We are dealing here with a case.
My lord,
For some relief.
please see page 72.
Now, this effect of stigma, once you are out of that organization, where will it go? You tell us.
My lord, please see page
No, first answer our query. Once you are out of this department, will you say an estimate?
I've been answered.
He is saying it 10 times does not increase its intensity. You have already said that. Sufficient times, unceremoniously, stigma. This you have said. So we are asking you, once you are out of this department, unceremoniously, where this stigma is going to affect?
It is going to affect me for the rest of my life. This will.
So after this, once you have got
Promotion does not mean.
what is the date of promotion? Give us the date.
I do not have the date. Right now, it is not with me in the papers. It is not with me in the
But you have admitted after taking
instructions, my lord, oral
it's an admitted position. It is an admitted position.
My lord, promotion.
Promotion to which post? Do you have the information?
My lord, I also don't know. My lord, they only said, my lord, I have.
You have no right.
Sir, please see page 72 for a moment.
For what?
My lord, kindly see for a moment.
Please read.
My lord, premature reversion of deputation is to a parent cadre. That is the part of the rules. Normally, when an employee is appointed on deputation, foreign service, his services are placed at the disposal of the parent ministry department at the end of the tenure. However, as and when a situation arises for premature reversion to the parent cadre of the deputationist, his services could be so returned after giving an advance notice of at least 3 months to the lending ministry and the employee concerned. You know, when a situation arises for premature, this situation arises for premature has to be, you know, commensurate with non-voluntariness. It has to not flow. Decisions has to be read into it. Natural justice has to be read into it. A situation arises. I put this question entirely to myself. What is the situation which prompted them to withdraw my appointment order on deputation within the shortest span of time? Because maybe there may be some oblique motive, some reason somewhere which existed in their file. As and when the situation arises, what is, I put this question to myself, first order was unreasoned. They withdraw it. The second order is page 40.
This provision I have considered in a judgment. This provision I have considered in a division bench. Here only. The same submission. That a situation arises has to be a speaking order.
And that is also one of the limbs of my submission. Well, I have to look into a lot. I have not looked into it.
No, I have considered this position.
But my lord, the trajectory of facts, my lord, do not, my lord, behave, my lord, very high about the organization, my lord, which took me on deputation.
All the more better you are out of it.
No. My lord, kindly visualize. My lord, I have offered my candidature for a
All right, so that is your submission.
Those are my. My lord, apart from that, the judgment. My lord, kindly see the judgment. My lord, please see, it is on the. It is with your lordship records, perhaps not 2012 7 CC. 11 paragraph. Paragraph 13 and 14.
2012 SCC.
Page 757.
This is from the earlier case.
What's the
year was that?
Paragraph 13 and 14. My lord, I'm giving you a lot.
You have given earlier.
Seven 575. 2012 SCC 757. Yes.
May not please see paragraph 13 first, and may not kindly see paragraph 14 thereafter. Ordinarily, transfers of deputation are made as against equivalent post from one cadre to another, one department to another, one organization to another, or one government to another. In such, I'm sorry.
Please have a look. Memory serves me correctly. I have considered all these judgments.
I will.
So that you don't persuade me to take a contrary view to my list.
I'll try to.
Therefore, I should do it consciously if I have to.
I'll try to. Look, I take paragraph 14 once.
Yes.
However, the aforesaid principle, aforesaid principle is in the light of paragraph 13. Cannot be made applicable in the matter of appointment on deputation. In such case, for appointment on deputation in the services of the state or organizations of state within the meaning of Article 12 of the Constitution, the provisions of Article 14 and 16 are to be followed. No person can be discriminated, nor is it open to the appointing authority to act arbitrarily or to pass any order in violation of Article 14 of the Constitution.
But there is an issue of repatriation in this case.
Yes. Well, here.
Where is the order of repatriation? In which paragraph?
Please see.
This is a case of cancellation of appointment. This is not a case of repatriation. This is after participating in the process for deputation by way of selection. There is an unfairness alleged. This is not a case of exercise of option to repatriate by giving a 3-month notice. Any other judgment?
My answer to your lordship is
no. Your answer cannot be divorce the facts of this case. In this case,
I am trying to only say this that my lord, someone who had
if you had been discriminated at the time of appointment, you would have had a better case. We agree with that.
My lord, this is after post appointment also a person who is appointed on the
also does not on that law. Any other judgment? This is only in the process of recruitment.
Sure. Well, I say, my lord, that appointment on deputation is covered by Article 14.
Sure. There is we accept that submission.
My lord, someone is appointed.
Any other judgment?
My lord, no other judgment. Someone who is appointed on deputation. My lord,
this judgment does not help.
My lord, with respect, it does.
This is only in the process.
But it does, my lord, with respect. Paragraph 14.
Just shows the order of reversion. Get the order of reversion in this case, which you are relying upon.
Not kindly. But here it is a case of someone else being selected.
Very well. Yes. Please, still I am requesting you, please, if you can find that judgment, which has. we have delivered.
Well, I can, just now I can't, I'll come back.
Obviously, we are not asking you to give us right now. Come with it tomorrow. You can find it tomorrow or day after, whatever you want. I will also look. I will also try to find it.
If it is Miller in the SCC online, then definitely it will be.
I don't know, but I should get it in my.
Miller, just Miller, kindly pardon me, Miller, I am putting this to myself. Miller, round about the time, Miller, your lordship will recall.
Has to be within 3 years.
No.
Has to be within 3 years.
I'll try to lay my hands on.
I think maybe within the last 9-10 months.
I'll try to lay my. Miller, kindly gives me.
I think
Next Tuesday, Miller,
I think we considered this judgment also.
Miller, kindly keeps it next.
There also the deputation was concerned with the defense ministry.
I shall try to lay my hands on.
There are a lot of allegations was leveled of bias and all against the ministry officials also.
Miller, kindly gives me the weekend.
All right. We can have it in the next week. Please ask your team also if they can find out. In the meantime, yes, if you can come out with the promotion order, we would like to see that also. Next week, which date will suit you?
Subject to your lordship's convenience, Miller, if it can. Next Tuesday. Next Tuesday.
Huh? You expect us to remember the name really? I mean, can we do it? Can we make Prabhu? This is the one. Visakhapatnam. No, okay. So you share it with him, right?
He knows it. No, I don't.
What is the date of that judgment, sir? October 20.
It should have been reported. This must be reported. Definitely it should be reported. October 25. Yes, we should try and find out.
Frame 11.
We have a delay of 16 days, your lordship.
How many days?
16 days.
16.
Excellent.
It is in application, it is mentioned 16 days, your lordship. I am a stamp reporter's report. I am not aware.
Right.
My application, it is mentioned 16 days.
Let us see. Come to the impugned order.
Your lordship. The order is dated 4th of April 2023.
What is the significance of January 21?
Your Lordship, in January 21, Your Lordship,
Oh, the order was set aside.
the earlier order was set
Where is
aside.
the division bench order?
Your Lordship, the division bench order is at page 45 of my stay application, Your Lordship.
Whether the division bench has taken into consideration the order passed in WP 21812. This MAT 111 of 2020 is arising out of which case?
It is in respect of Your Lordship WP 21812 of 2012 and 15648 of 2013. Both were filed together, Your Lordship, as there was a common order. Subsequently, that was reflected as a defect, Your Lordship. That was subsequently what I read from the order, Your Lordship. It has been corrected.
So where is the order of, is there any other writ petition prior to 21812?
Yes, Lordship. The earlier order was at page 20, Your Lordship. Another writ petition.
20261.
Page
20.
20261, Your Lordship.
But this
Another writ petition, private respondent, another writ petition, another person has filed the writ petition. This respondent number 1 herein has been added as respondent number 10 therein, Your Lordship. It has been alleged that
that's not the point, sir. Presently we are dealing with the case of one Monica Ghosh. Monica Ghosh was not a petitioner in WP number 20261.
not petitioner, she was respondent number 10 therein. Her appointment was cancelled on basis of order passed as per direction of this
20261.
Yes, sir. The impugned order at page 36 is the order, Your Lordship, which was passed in terms of order passed by the Honorable Justice, Honorable Single Bench on 10/5/2012 in 20261.
So this is for the post of?
This is for second ANM.
Second ANM.
Yes,
second ANM, and then there after the order passed in the writ petition, the district magistrate afforded an opportunity of hearing.
Yes,
and the final order was passed on which date?
The final order was passed on 28/6/2012, Your Lordship. That is at page 36, Your Lordship.
So this writ petition was filed challenging the appointment of this writ petition?
Yes, not this written, Your Lordship. Earlier petition of 2012 was filed challenging the appointment of this Monica Ghosh, Your Lordship. Accordingly,
just now you said that she was respondent number 10 in 20261.
The writ petitioner therein has challenged her appointment, Your
Correct.
Lordship.
That's what we are saying, that Munmun Paral
Yes,
has challenged the appointment of Monica Ghosh, who was respondent number 10.
Yes, Your Lordship.
So thereafter, the district magistrate was directed to give a hearing. He has given a hearing and he has found that
appointment was not proper, Your Lordship. The
appointment was not proper.
Yes, Your Lordship.
Final order is of which date?
That is at 12, Your Lordship, 28/6/2012.
28/6/2012.
Yes, sir. At page 36, it starts, Your Lordship.
Oh, it is the same order. So the selection was held invalid.
Invalid, Your Lordship.
Then after that, she was never selected.
Thereafter, Your Lordship, she filed a writ petition.
Then came 21812.
Yes, Your Lordship. 21812. There, Your Lordship, the single judge directed for appointment advertisement to be published, Your Lordship. But as the central government has passed issued a circular stating that the second NM will no longer be continued, Your Lordship, a fresh post was created.
So therefore, what we are just trying to ascertain a fact that after declaration of invalidity regarding her selection on 28/6/12, she was never working.
No, she was selected as a result of this order passed by the Honorable Division Bench. That starts at page 45, Your Lordship, 15 January 2021.
Page 28. Page 28. So the division bench passed an order when in 21.
21, Your Lordship.
After this, she was appointed.
After this, she was appointed and she was. Yes, Your Lordship.
What is
After
the
this,
date? What is the date on which she was appointed?
She was appointed, Your Lordship. She joined on.
No, where is the letter appointing her?
Yes, sir.
Order.
Her joining letter is annexed, Your Lordship, at page 80. That was
There is
annexed
no
to the-
order. There is no order
There is
appointing.
no other copy, Your Lordship, herein.
No other copy.
Which is not, that was not part of writ petition, Your Lordship.
So you should have brought it on record.
It is not there, Your Lordship.
Engagement letter is of 3/12/2010.
Yes, Your Lordship.
And she has joined according to this joining on. What is the date?
She has mentioned it as joining report dated 3/12/2010.
No, on the left side there is a. It is not legible, but there appears.
Allowed to join and forwarded to
Your Lordship,
3/12/2010.
Yes, sir.
Same date.
Allowed to join.
3/12/2010. Same date. So after 3/12/2010, she is working.
She started working, Your Lordship. Thereafter, she filed this writ petition, Your Lordship. She claimed for back wages for fourth unemployment.
Yes. Prior to that, scholarship has already. No, she has given something. This is nothing. This is another school. She can. Successful. All of it. You serve a notice. What is the can for condonation?
It has to be can 1, Your Lordship.
Can 1 is dismissed as not pressed. There is no delay reported by. We are the learned advocate for the appellant.
Resolution লিখে দিয়েছি হয়ে গেছে এবার শেষ I've gone through the resolution.
Two PM at item number 66.
My lord, is that matter, my lord? The virus has been challenged, my lord. I am answering.
Item 67.
They are appearing on behalf of the respondent deputy sir. Mr. Trivedi, he has concluded his argument, I think. Call the next.
68 and 69.
Appearing for the appellant lordship led by Mr. Ramdullah.
Item 70. 71.
71, I appear for the PD. Yes, sir, we are here.
Lordship, it's a contempt matter. The judgment is of your lordship with Honorable Justice Prosenjit Biswas.
That is the
Mr. Mitra is leading in the matter. Your lordship may remember that Coal India one.
Coal India matters.
No, your lordship, Mr. Mitra sat with the client. We want to file an affidavit also, but your lordship will pray before the concerned bench.
Okay.
So, appearance.
13. 14. 15. 16. 17.
Not to divide.
18. 19. 20. 21. 22. 23. 24. 25. 26. 27 and 28. 29. 30. 31. 32 and 33. 34. 35. 36. 37. 38. 39. 40. 41 and 42. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56.
Item number 18, I am appearing for the appellants. Very good. I was on my way, I could not reach.
All the next.
57. 58. 59. 60. 61. 62. 63. 64. 65.